We're live.
Are we live?
Yes.
All right. So good morning, everybody. This is the Coastal Permit Administrator hearing for July 8th, 2021. And I will go ahead and call the meeting to order at 11:02 a.m. And moving to item 2, do we have a determination of noticing?
Yeah, legal notice has been determined.
All right. So I'm going to go ahead and move things around a little bit. I'm going to go ahead and start with the second case on the agenda, which I'm finding that there's an error because they're both number 3B. Should be 3A and 3B. So I'm going to start with 3B, which is a Coastal Development Permit 2020-0027. The applicant is Tung Nguyen. Standard Coastal Development Permit to install a 1,200-gallon concrete septic tank, a 2,400-gallon water tank, interior remodel and grading. The project is located in the coastal zone, 2.9 miles south of Albion Town Center on the west side of the Navarro Bluff Road, approximately 394 plus or minus feet northwest of its intersection with Highway 1, located at 1330 Navarro Bluff Road in Albion, assessor's parcel number 126-13006. Project has been determined to be categorically exempt. And again, for those of you that are just joining us, I am taking the cases out of order. I'm starting with the 3B first, as opposed to 3A in the agenda. And the agenda should be corrected to reflect that the Booth case is 3A. So we're starting with 3B, which is the Nguyen case. All right, so staff, can I get a staff report?
Yes, good morning. Mark Kleiser, Planner 2, planner for this project. As indicated, this project is for a 1,200-gallon concrete septic tank and existing 24-gallon water tank, which was installed by the previous owner, and grading to allow for pavers. The project is located on the west side of Navarro Bluff Road and east of the Pacific Ocean. It is zoned rural residential with the western portion inside the development limitations and floodplain combining district. Existing permitted structures on the parcel include a 1,344 square foot single family residence with attached garage. Development is concentrated on the east side of the parcel and is set back sufficiently from the bluff edge. Though located west of Highway 1, the parcel itself is not located in a highly scenic area. Referrals were sent to responsible agencies on March 17, 2021. CDFW comments state that the project is unlikely to impact any species of concern, but limits placement of soil no closer than 50 feet to the bluff top. This is addressed in condition number 11. Environmental Health has requested maps showing the distance between septic and leach lines prior to issuing septic tank replacement permit, and this has been addressed in condition number 10. No other comments of concern were received. All aspects of the project are principally permitted uses as identified for the rural residential land use classification, and development is limited to the portion of the parcel which is not located, in the development limitations and floodplain combining district. As indicated, the project is categorically exempt from CEQA. The project is appealable, and staff recommends approval of the project with conditions. That concludes the presentation.
Thank you. So for clarification, this is just merely a septic tank, correct?
Yes.
Okay, and when we talk about interior remodel, we're talking about the interior remodel to the house or
Yes.
to the tank?
To the house. They are redoing the floors and remodeling the kitchen and bathroom.
And the grading?
And the grading is approximately 2,400 square feet will be covered by the pavers. Excess soil will be put into existing planter boxes on site.
Okay. And the permit for the septic tank basically As this permit is considering also the leach lines, correct?
Yes.
Okay. All right. So with that, I will go ahead and ask that the applicant, if the applicant has anything to say on this matter.
I do not show an applicant at
We
present.
do not show an applicant.
No.
All right, do we have, and I guess my next question is, since the applicant is not present, do we have any members of the public that wish to speak on this matter?
Not on this matter yet.
Not on this matter. So what I'll do is I'll return it back to the coastal permit administrator, and I have reviewed the staff report, listened to the findings, and I guess my next question is, do we have any correspondence that's come in on this matter?
I did not receive any
All right.
correspondence.
All right, so with that said, thank you very much. Just wanted to double check to see if any correspondence has come in. I've gone through and reviewed the environmental determination, the project request, and the findings and conditions contained in the staff report. So I'm going to go ahead and approve the project, subject to the findings contained in the staff report, as well as the conditions of approval. So the project is approved.
Thank you.
And again, Mark, you indicated that this project is appealable. There is an appeal process, and I'll just cite that persons who are dissatisfied with the decision of the coastal permit administrator may appeal the action to the Board of Supervisors. An appeal must be made in writing along with an applicable fee to the clerk of the board within 10 days of the coastal permit administrator's decision. The appeal issue will be placed on the next available Board of Supervisors agenda for consideration, and the appellant will be notified of the date and time and date. Appeals to the Board of Supervisors do not necessarily guarantee that the coastal permit administrator's decision will be overturned. In some cases, the Board of Supervisors may not have the legal authority to overturn the decision of the administrator. All right, so with that said, we're going to go ahead and move to the next case, which was the first case. All right, so thank you, Mark. So this is the continued item from June 10th, 2021. This is CDP 2020-0024. The applicant is Paula Janice Booth. The agent is Wind Coastal Planning and Biology. The request is a standard coastal development permit to construct a single-family residence, including attached decking, patios, and garage. The request includes the installation of mitigation fencing, a primary septic system, and a future vested opportunity to install a replacement septic system. Associated development includes the establishment of a propane tank, a gravel driveway, trenching for underground utilities, and connection to community water district. The environmental determination is a mitigated negative declaration. The property is located within the coastal zone, 0.5 plus or minus miles south of the town of Albion Center, within the Pacific Reef subdivision, and on the northeast side of Pacific Reefs Road, approximately 0.5 plus or minus miles west of its intersection with State Route 1, located at 34350 Pacific Reefs Road. In Albion, such as parcel number 123344013. And also, I would like to note for the record that the coastal permit administrator visited the site on June 23rd, the afternoon of June 23rd, and to become familiar with the property. So with that, I will go ahead and ask staff for a presentation.
Gonzalez. This is Jesse Waldman, planner for Mendocino County Planning and Building Services. And yes, this is a coastal development permit request to develop a vacant parcel that is located within a gated subdivision, the Pacific Reef subdivision. It is between the Pacific Ocean and the First Public Road, Highway 1, located at 34350 Pacific Reefs Road. The proposed development includes the proposal to construct a single-family residence with attached decking, patio, and a garage. The request includes the installation of mitigation fencing, a primary septic system, the possibility of future option to install a replacement septic system. The associated development includes the installation of a propane tank, a gravel driveway, and trenching for underground utilities and connection to the water district located within Pacific Reefs. The parcel is roughly 1.3 acres in size. It is subject to the rural residential classifications in the coastal element. It does have the option for it. It is zoned RR51 if it has proof of water for an alternative density of being less than 5 acres. The zoning is the rural residential zoning district. It does have a development limitations combining district, which no development is proposed within the development limitations area of this parcel, and all development will be located within the rural residential zoning district. The parcel is, as proposed, the development is consistent with the local coastal program for classifications of rural residential, the zoning regulations for setbacks, building heights, parking, proper water, proper sewage disposal on site. The parcel is not mapped as a highly scenic parcel, and it is subject to the coastal elements chapters 3, sections 3.5-1. The parcel has been reviewed with respects to our coastal element, and the building heights, the colors, the building heights, the setbacks are consistent with the surrounding neighborhoods and the coastal element and the rural residential zoning district. There is has been multiple studies done on this site as discussed within the staff report, and that includes a biological scoping survey, report of compliance, the takings analysis, the geotechnical report. There has been a setback reduction granted by CAL FIRE, and there's also been an archaeological survey. Staff has found that there will be impact to ESHA based on the proposed development. Alternative designs were proposed, and they are presented in the takings analysis as well as the biological scoping survey and report of compliance. Mitigation measures have been proposed for this project to prevent impacts to ESHA, and I will discuss those further. Staff is recommending conditions for a exterior lighting plan and exterior finish plan to verify that the proposed development will be consistent with the visual resources. Going through the staff report, and there's hazards, and in the hazard management, this is where we reviewed the geotechnical report as well as the design criteria for development on bluff top parcels. The geotechnical report made recommendations that no development shall occur within 46 feet of the bluff top edge. Condition 13 recommends this be adhered to, which means that the site plan that is proposed by the applicant and their agent, that a mitigation fence would need to be relocated. There are further conditions recommended that a new site plan showing landscaping and including all of the buffer requirements for this parcel be presented and approved by the Mendocino County Director, the Director of Mendocino County Planning and Building Services, the CPA, or their designees. This would secure that any development would not be, this would secure that all development on this parcel proposed or approved is consistent with the geotechnical report, as well as protection of ESHA. And I will be talking about ESHA in just a few minutes. There will be also in the conditions that are prepared by staff in the second memorandum that's been posted on our website and prepared. There are going to be mitigations that require not only a landscaping plan, but also a staging plan for all construction and development of this parcel. These will need to be provided, reviewed, and approved by Mendocino County's Director, CPA, in consultation with CDFW and the California Coastal Commission to verify that these staging plans, landscaping plans, all take into consideration the knowledge of the landowners for protection of the bluff and ESHA on this parcel. That is going to be specifically recommended in conditions number 22, A and B, as part of the mitigation plans. There has been also revisions made to the recommended staff report in the second memorandum that is available on our website dated July 7th, yesterday, that discuss the habitat and mitigation monitoring and reporting plan and the steps to present that to the Mendocino County Planning and Building Services, steps to monitor, which is a 5-year monitoring plan with annual reporting with succession, and if not successful, that it will happen for an additional 2 years annually. The takings analysis, and I presented a portion of the taking analysis within the second memorandum prepared, show the alternative design approaches and discussion from the qualified biologist that was hired by the landowner. And it talks about the different levels of impact to the environmental sensitive habitat area. This parcel has a coastal wetland that is on the southwest corner of this parcel, as well as sensitive plant habitat areas, where the monitoring plan will be working specifically with monitoring the reestablishment of specific special status plants. This will need to be submitted to us prior to the issuance of this coastal development permit, should this permit be approved. That would like, one moment. We will be grading on the parcel to develop the driveway, the foundation, as well as the septic system. And conditions are recommended within the staff report, as well as in the memorandum specific to the staging and prevention of further impact to ESHA for that grading on the parcel. The archaeological report was accepted at the Mendocino County Archaeological Commission in November of 2020. And standard or recommended condition 8 applies for any discovery clause. The project will not contribute to new sources of traffic on local or regional roadways. Access to the parcel will be provided through Pacific Reefs Road, which is a private road. The project was referred to the Department of Transportation with no comments for the proposed project. This project does have a requirement of a minimum of 2 parking spaces, which are proposed on the site plan. And staff finds the project is consistent with transportation and circulation requirements. The development does not propose a the project site is not designated as a potential public access point on the certified LCP maps. Public access would not be feasible on the site due to the extensive sensitive habitat areas. If the mitigation and monitoring plans are followed, the project would be in conformance with public access policies for Mendocino County Code. And staff would like to take this opportunity to review the second memorandum that was prepared and is available on our website. Our office has received multiple comments since the beginning of this project being publicly noticed, including comments from the California Coastal Commission, where they recommended revisions to the proposed conditions 11, 20, and 23, as well as further conditions regarding further development and possible risks to environmentally sensitive habitat areas. I will discuss that further. On June 3rd, staff received additional comments from WIN Coastal Planning and Biology specific to the habitats and resources section, and that is also inside of this memorandum with recommendations, with multiple comments, requests, revisions, and recommendations for changes to the staff report's recommended conditions of approval. Staff has also received multiple public comments expressing concerns of the impacts of this project on visual resources to adjacent parcels, including story poles, consideration of private view sheds, which will be addressed as part of the county review process of this project. Also, on June 17th, planning staff received additional comments from the California Coastal Commission, as well as from the CDFW, where the Coastal Commission recommended revisions to the conditions as stated 11, 20, and 23, with further recommendations for conditions to prevent impact to ESHA. I know I'm repeating myself, but there's been multiple conversations on this, multiple comments provided. Also, between the last CPA hearing on June 10th through July 6th, 7th, and 8th, planning staff received additional comments from WIN Coastal Planning and other public comments regarding ESHA and visual resources. In the memorandum, I have reiterated and I've also tried to provide clarification regarding that this parcel is not a highly scenic parcel and it is subject to certain design criteria of the coastal element, chapter 3.5. The allowed building height is 28 feet for Mendocino County zoning regulations for rural residential. The proposed building height is 16 feet, 10 inches. The average proposed building height is 16 feet, 10 inches, and that is consistent with the rural residential zoning district. While portions of the proposed residence will be visible from State Route 1, the development will not be adding additional view obstructions to the ocean from Highway 1. The proposed project would not be visible from any public areas, any recreation areas, and would not be considered out of character with surrounding development. Staff has determined that the project will be consistent with Mendocino County Coastal Elements 3.5-1 and also the County Code of Regulations chapters 20.488 and 504 for parcels to be developed along the ocean, Pacific Ocean, and scenic coastal areas. This is also why story poles were not required by the Planning Division of Mendocino County Planning and Building Services. The condition for exterior finishes and exterior lighting will stand to adhere to the coastal element and the zoning regulations. I would also like to make additional clarifications to staff reports sections for habitats and natural resources and the takings analysis, where I've attached a portion of the takings analysis to this memorandum to show the different alternatives, which I stated earlier. There needs to be a clarification that the mitigation row fence in the staff report should say a low wooded or rope mitigation fence, not a row mitigation fence, and that this proposed fence was proposed at 15 feet away from the bluff top edge, and it shall not be located within 46 feet to be consistent with the geotechnical report, which stated that no development shall be permitted within 46 feet of the bluff top edge, quote unquote, from Brunsing's analysis. Staff included that staff wants to clarify that this includes the proposed mitigation fencing. The mitigation fencing shall be consistent as shown within, there should be a clarification on this memorandum. It's recommended that the mitigation fence is going to be on the staging plan and also on the landscaping plan that is going to be recommended in conditions 22 and 22A and B, and that is recommended to happen before the issuance of this CDP, should the CDP be approved. I've added some revisions for clarification into the findings, specifically 1, 4, 7, and 8, where there are the mitigation recommendations are conditions 12 through 24. There's additional revisions added to the conditions of approval, including 11, 12, 20, and 23. And this is all with respects to a deed restriction being required, that these mitigation conditions would be recorded on the property for the life of the property. These revisions would also include specific monitoring plans. So when we see the monitoring plan come into our office, we know what we're looking for. We have shared the memorandum with the California Coastal Commission and with CDFW. They had comments, the July 17th comments. They have not responded to this memorandum today, but staff does believe that the comments provided on June 17th from the Coastal Commission and the recommended conditions in this memorandum, they would be consistent with the goals for the coastal element and for the Coastal Commission as well as CDFW. Staff would like to clarify that 2 additional conditions of approval have been recommended, and it's condition number 25 in the memorandum, where any building permit shall include all conditions of approval of the Coastal Development Permit 2020-0024 be attached to and or printed to the plan submitted. Also 26 would be that prior to inspection of the installation of any foundation associated with this coastal development permit, that the Planning Division of Mendocino County Planning and Building Services shall conduct a site inspection to ensure development is consistent with all setback limitations and the staging plan as described in condition 20 are properly implemented. If you would like me to go over further conditions recommended in this memorandum, I am able to do so now. Further comment has been submitted this morning, which have been posted online and shared with the agents. And staff would recommend, let me verify my notes. Staff would recommend that there could be possible discussion of a further condition of approval, being that if any changes to the CPA's approved staging plan and landscaping plan that shows all development, all buffers, if there's any deviation of that, then an amendment to this coastal development permit be applied for should any relocation of structures or changes to the structure occur. That is based on my review of my memorandum and all comments and all review of this project since the July 10th CPA hearing. And I am prepared to state that condition if needed. Staff would recommend approval of this project with the memorandum that was prepared, and that this project is a mitigated negative declaration project, and the monitoring plans, the mitigation recommendations would allow that to be consistent with our coastal element and our zoning regulations. That concludes my report, and if you have further questions, I am available to assist.
Okay, thank you. Thank you for that detailed report. So at this time, I'll go ahead and ask the applicant if they have any comments.
Hi, this is Tara Jackson. Can you hear me?
Yes.
Hi, Tara Jackson, agent for the applicant with Wind Coastal Planning and Biology. Thank you, Jesse Waldman and Planning Building Services for your attention to this project. Because there has been additional public commentary posted to the county website today, July 8th, 2021, we request that the project be continued to a date uncertain. We would like the opportunity to coordinate further in light of the recent comments. However, before continuing the hearing, I would like to make a couple statements for the record. And am I able to share my screen?
I believe so.
Okay, let me. I have to make her
I think you have to make her
a co-host,
yeah,
a panelist.
panelist.
Yep.
So,
Okay.
so Tara, go ahead.
Are you able to see my screen?
Yes.
So I, first of all, want to point to the memo that was submitted yesterday from our firm in Coastal Planning and Biology and was posted to the county website this morning. The purpose of which is in citing coastal element policy 3.5-1 visual resources. Permitted development shall be sited and designed to protect views to and along the ocean and scenic coastal areas to minimize the alteration of natural landforms to be visually compatible with the character of surrounding areas. First of all, I want to reiterate which has already been stated in a previous hearing that the protect views refers to the public views, not private. And as stated by Jesse Waldman, this proposed development does not create a new visual obstruction between a scenic highway or a public recreation area. It is surrounded by development on all sides. As is evident in our visual, we used the same line of sight that had been submitted by a member of the public and interested party. And so using that line of sight, there is already 2 houses within that very same line of sight. So this proposed development will essentially be in that direct line and is therefore in character with the surrounding development. And also, you know, the colors and the material also show that it is in character with the surrounding development. I also want to point out, it had been noticed that it's not compatible. Some had pointed out that it's not compatible due to its proximity to the bluff, and that other houses in the neighborhood are further away, and that in stating that septic systems should be allowed on the bluff side as opposed to the more inland side that's different from the surrounding development because they have septic systems. And that I just want to point out for the record that those septic systems, as stated in the public commentary, were installed and permitted about 30 years ago, in which there was actually a different review process for coastal development permit. Furthermore, geotechnical analysis is updated as the science changes over time. For example, sea level rise is something that is now taken into consideration, which wouldn't have been 30 years ago. And you know, with that, even geotechnical, sometimes these reports need to be updated every 5 years because the science changes so frequently. Additionally, let me see here. There was, in referring to whether this development is in character with the surrounding development, it was pointed out in a public commentary that the 20-foot setback was brought up as a civil issue, not a county process issue, but a civil issue per the CCNRs but it was referenced as contradicting the visual character of the neighborhood. The following APN, so these houses, we did our own analysis, show that single-family residents in the neighborhood are actually also within 20 feet of the side yard property lines. So we have one on the western side. These are approximate, but this looks like it's approximately 5 feet. We can assume that it is in conformance with county code, and it is 6 feet. The neighbor to the east is approximately 17 feet. This, we were only able to measure between houses, so it's about 40 feet between them, so they probably are conforming to 20 feet setbacks. And then between these two houses, you have a 30 feet between the two houses, meaning that one of them is not conforming to 20 feet. So again, this is just to reiterate that the proposed development is in fact in character with the surrounding development. There's also a house across the street that was approved with a 6-foot side yard setback. Also for the record, for recent similar projects, the Architectural Control Committee, which I acknowledge is a civil issue, not that which the county interacts with, but for the record, the Architectural Control Committee has not been active for recent similar projects and has not reached out to us regarding this project. Also, we submitted the application on September 9th, 2020, and the neighbors, the Buchlers to the east, have been providing commentary to the county since October 2020. They have mentioned that they have not had an opportunity to provide commentary and be a part of this process. However, they have been providing commentary since October 2020, 1 month after it was submitted, and have therefore been active participants in the project since the beginning. Furthermore, our mailing list and envelopes included their 2601 Stratford Drive, Austin, Texas address. So thank you very much for letting me go through some of those points for the record. And again, in light of some of the recent commentary, we do believe that there is further coordination that needs to occur and address some potential issues that were brought up, and we do request that the project be continued to a date uncertain.
Thank you. Tara, I have a question for you.
Yeah.
So again, talk to me about the alternatives that were considered, alternative A and alternative B.
Mm-hmm.
And what makes one more environmentally preferred than the other?
Right, so that is in large part having to do with the septic system and where that is located. So alternative A's and B's have, and I'm speaking as a planner, not a biologist, but they have comparable impacts to the environment in that they would have direct development on top of the headland wallflower, whether it be alternative A or B. However, alternative B puts the actual single-family residence closer to a coastal act wetland, as opposed to having the septic system near the coastal act wetland. So it is considered less of an impact for that reason, because it's a different type of development within proximity to a certain high-quality ESHA, which is a coastal act wetland. Now, when you take that and then you compound it with the geotechnical analysis, in that it is safer to have the septic system further away from the bluff. So when you take those different considerations into account, we came to the conclusion that alternative A was the least environmentally impacting alternative.
Thank you. Appreciate that explanation. Is there anything else that you would like to add?
There is nothing else at this point in.
All right, thank you. I see Amy's on the line. Is there anything that you would like to add?
Hi, this is Amy Wynn with Coastal Planning and Biology. I have nothing to add. Thank you so much.
All right, thank you. So at this point, I will go ahead and open the public hearing, and I'd like to hear from the public.
Okay. This is the point where we address any telecommenters that have been submitted. Their forms are waiting, and they are waiting in line. I will read the list in order and call the next speaker. When called to speak, please state your name for the record. Public comment is limited to 3 minutes per person. Speakers are asked to please address the comments to the coastal permit administrator and to refrain from using profanity or engaging in conversation with members of the audience or staff. So we'll go to the first speaker, which is Mr. Buechler.
Good morning.
Hello.
This is Cindy.
Okay, so I'm going to start the timer at 3 minutes, and I'll give you a 30-second warning.
Thank you. My name is Cynthia Buechler. My husband and I own the property directly adjacent to the east of the proposed project. My husband Bill spoke during the June 10th hearing on this matter. We are represented in these proceedings now by Alex Merritt with the Shepherd Mullen Law Firm. We incorporate his letter that was filed and the public statements he has made as our own. We have had the privilege of owning our home in Albion for 11 years. We had our honeymoon in Mendocino County 28 years ago, and we're delighted to be able to call this little piece of paradise our home several years later. When we bought the property, the realtor showed that the adjacent property was wetlands and was protected. We also reviewed the deed restrictions and the status of the environment at the closing, which would preclude someone from building close to the bluff. Based on this information, we fully expected any future construction would be required to stay within the character of the neighborhood. Even though we own the property directly adjacent to this proposed project, we were not given any notice that it was under construction. The applicants never contacted us to let us know, nor did their agents or the county. If it had not been for our neighbor, Flint Holtzkamp, due diligence, we would not have known what had transpired before construction began. Once we became aware of this project, our neighbors and ourselves both emailed and phoned Ms. Jessie Waldman in October and November 2020, asking to receive notice of any action would be taken in this case. She indicated that she would provide notice. Regrettably, though, a week later, there was apparently an archaeological commission hearing to which she did not provide any notice to us, any of the neighbors, in fact. However, she timely emailed the applicant's agent, Ms. Jackson, with Wincoast to ensure her participation. Both ourselves and Mr. Holtzkamp asked Ms. Waldman for story poles. Ms. Waldman never responded. This is the first time I've heard her respond as to why she wouldn't do that. I emailed her in March again and asked for story poles and to be provided notice of any action that was being proposed. However, Ms. Waldman never proposed any notice, even though the records we asked for in the Open Records Act show that she was in constant communication with Ms. Jackson and Ms. Wynn at Wynn Coastal throughout the entire process. Had we been given notice about the archaeological commission, we would have participated as soon as we became aware that this was happening. This proposed project would have a devastating impact on our property and many other neighbors. We have loved the tranquility of our oceanfront property and the majestic views it has afforded us and our family. These views will be significantly and negatively impacted. We have reached out to the applicants to find an informal
30 seconds.
resolution, but they have declined. This morning is a date. We have this setback that was just showed is disingenuous. It shows the side of our house. It does not show that it's blocking our views from both our living room, our family room, and our kitchen. In addition to it, it doesn't show how close it is to our property. It does not have the required 20 feet setback. It is also proven though that the light pollution we're going to suffer from it being where it's located. We do want to continue to do an amicable resolution within the deed restrictions and the law. However, again, they have not reached out to us since we have reached out to them twice. And secondly, we want to make sure that you know that we as homeowners fully intend to enforce our rights under the law and under the deed restrictions to keep those in place. They were put in place to protect the neighborhood, and it does not, contrary to Ms. Wynn's statements, it is not in the character of the neighborhood. And in fact, it is going to be significantly difficult for us, and it's going to cause great blockage of our views and the enjoyment of our property and invasion of our privacy. And so we respectfully request that this permit be denied.
Thank you. Anyone else? Next speaker.
The next speaker will be Alex Merritt, and then after that will be Flint Pumskamp.
Good morning, can you hear me?
Yes.
Yes, go ahead. Please state your name for the record.
Good morning, this is Alex Merritt. I'm with the Shepherd Mullen Law Firm. We represent the Buchlers, the neighboring property owners. I just want to emphasize, following up from the last comment, that the Buchlers do not oppose development of a house on this lot, but the current design has significant problems and can't legally be built. And so we're here to ask that the county deny the permit and require a redesign. Those problems are detailed in our comment letter, which we submitted. I just briefly want to emphasize a few key points. The first relates to the CC&Rs. This property is subject to the Pacific Reef CC&Rs, which govern all the lots in the neighborhood, and Restriction 19 requires a 20-foot side setback. This project violates that requirement, includes only a 6-foot side setback, and the Buchlers have a private right to enforce that restriction. So even if the county grants this permit, a court will enjoin the development of the project. So this is a meaningless exercise. There's no reason to spend time permitting a project that can't be built. It's unfortunate that it's come to this, but the applicants have refused to meet with or engage with their neighbors. If they had, they would have realized this limitation earlier, and everyone could have worked out an acceptable design before this came forward for hearing. But now we're in the situation that we're in. A second problem relates to CEQA. There are a number of problems in the M&D that are detailed in our letter. A key problem is that the M&D admits there are significant and unavoidable biology and land use impacts because the project violates ESHA requirements. Therefore, an EIR and a statement of overriding considerations are required. The M&D takes the position that because of the regulatory takings issue, the county can approve the least damaging alternative, even though there are unmitigated impacts. And that's simply wrong. The regulatory takings analysis is not relevant to CEQA, it's only relevant to the Coastal Act. The county can't override a significant and unavoidable impact in an M&D based on a regulatory taking. And then finally, as to the coastal requirements under the LCP, it's really not clear that this is the least environmentally damaging alternative. There are several problems with that analysis as set forth in our letter. Frankly, the design of this project seems to be motivated by building the largest house possible and siting it as close to the bluff as possible to maximize ocean views. The design does not appear to be geared toward minimizing environmental impacts as required. The Coastal Commission and the neighbors have identified other alternatives, and those were not given serious consideration. These may require reducing the size of the house or orienting it differently on the site. And I know that's not the applicant's preference, but that's what the LCP requires. And so we're hiring our own bio and geotech experts to peer review the applicant's studies. And if future proceedings are needed, we plan to submit those into the record as well. So again, we'd ask that you deny the permit today, or, as suggested by the applicant, perhaps indefinitely continue it to give the applicant time to fix the problems so that they can bring forward a design that can actually be built on this site. Thank you.
Thank you very much. All right, next speaker.
So if you're on a phone, you have to star 6 to speak.
Mr. Polskamp, star 6 to unmute.
Hello, can you hear me?
Yep.
Yes.
Oh, good. Thank you. Let me get back here. My name is Flint Polskamp. I am also a neighbor of the proposed development, and I strongly oppose this project as currently stated. My 3 minutes here, I just want to bring to attention the letter that I submitted immediately after the last meeting. At the end of that meeting, I believe the permit administrator asked a question to the agent of the applicant, who was Tara Jackson from Wind Coast Planning and Biology. And I believe that the permit administrator asked what was the reason for picking option A versus option B. And there were three reasons given that Ms. Jackson gave, all which were false and misleading. I laid those out in my email, and I just want to bring those up again because I hope those actually made it into the record and actually were noticed by the permit administrator. The first comment was that the issue in regards to the septic systems. The septic systems, I think she said that the septic system had less impact further inland, and properties on either side, three properties in particular, including mine, have a septic system between the house and the bluff. Yes, it's true. One of the speakers said that those were permitted many years ago, but none of those septic systems have had problems subsequent to their installation. And I believe that Tara Jackson said that posed a severe risk to the erosion to the hillside, if I remember her words right. And it's just not true. It's just very misleading. The second issue is in regards to the width of the lot. I think Ms. Jackson suggested that option A was the more viable option simply because of the narrower lot, narrower than the surrounding lots. That's simply not true also. That proposed lot from the applicant is as wide or wider than the lots on either side. And then thirdly, the proposed site in regards to the biological, botanical, and wetlands impact. If I'm looking at some of the reports showing the location of those wetlands and endangered species, I guess, or affected species, and it seems to me from an unprofessional eye that option B would be just as, or at least less impactful than A. And so for those reasons, I just wanted to bring those 3 points up. There's a lot of misinformation seems to be coming out in these talks, and I'm just trying to clarify the record. Thank you.
Thank you very much. So we've got some questions here that need to be answered. So I have a request from the applicant's agent to continue to a date uncertain. I've got the applicant, the neighbor's representative, Mr. Merritt, who would like to see the request denied, or he's even supportive of a continuance. I've got Buchlers who have indicated that they did not receive notice of the Archaeological Commission meeting, which again I'll point out for the record it's not required. And notices are sent out at the time of a hearing that is proposed for the CDP, and that would go to an address listed on your assessment. So it would be tied to your assessor's parcel number and so on. So if you've got a different address, that's probably where it went to. So in any case, at this point, there are some issues that Mr. Merritt raises that obviously need to be looked at. I've got the applicant's agent that wishes a continuance, so I'm going to go ahead and grant the continuance at this point in time to a date uncertain, and it'll provide all parties to do the necessary due diligence, and then bring this application back before the coastal permit administrator. As part of the continuance, this is just a notice to Ms. Jackson. The applicant will be required to pay a renoticing fee because there is to a date uncertain, so the thing has to be renoticed all over again. So again, continue to a date uncertain, applicant to pay the renoticing fee. All right, so that brings us to matters from staff on the agenda. Do we have any matters from staff?
I don't know matters.
All right. And do we have any matters from the public?
I don't have anything, I have received no.
All right.
information.
So with that, I will go ahead and adjourn the coastal permit administrator hearing at 11:57 a.m. Thanks, everybody.